Hello, everyone, and welcome to today's webinar, a look back at PBM audit trends and what pharmacies should do now to prepare for the new year. My name is Katie Guglielmo, and I'll be your moderator. I'm the marketing coordinator at Frier Levitt. I would like to introduce you to our speaker today, J.Y. Lee, Pharm.D. Esquire, CPBS. He is a pharmacist-attorney at Frier Levitt who has been challenging PBM audits on behalf of the pharmacies across the country and gearing them for the next PBM audits. Before we get started, I just want to take note that all lines have been muted. Also, I want to remind you that the Q&A tab on your screen. Go ahead and type in your questions throughout the webinar today. We will wait until the end of the presentation to answer those, but we will be sure to get to all of them, whether it's during this live webinar or in an email following today's presentation. This webinar will be recorded and sent to you in a follow-up email by the end of the week. So, without any further ado, I'd like to kick things off by welcoming Day. Day, you have the floor.
Thanks, Katie. Good afternoon. Thanks for joining me today. My name is Day Lee. I'm one of the pharmacist attorneys at Frier Levitt. I advise clients in a wide range of matters, including insurance and PBM audits and termination, wrongful recruitment, wrongful network exclusion, and government investigations. For plan sponsors, I provide full panoply of legal services ranging from PBM contract negotiations to contract disputes to enforce plan sponsor agreement terms and conditions. I also litigate high-profile commercial and personal injury cases. Today's webinar is informational purposes only, and it is not for the purpose of providing legal advice. So, Frier Levitt, my firm, is a national boutique life sciences and healthcare law firm. We have an army of attorneys with in-depth experience and backgrounds in pharmacy, hospital administration and professional licensing, attorney general actions, clinical practice, as well as medical billing. Through our experience in representing thousands of pharmacies across the country, we have developed a strong relationship with the key decision makers at each pharmacy benefit manager, and we have successfully fought on behalf of pharmacies and healthcare providers in conducting PBM audit appeals as well as disputes. Frier Levitt provides directed and uniquely tailored legal services to community pharmacies. Needless to say, this year has brought many challenges to individuals and businesses, including community pharmacies. Pharmacies had to treat patients and ensure that patients have access to health care during the pandemic, while dealing with lower reimbursement rates, as well as audits and recruitment imposed by PBMs. PBMs have continued placing pharmacies under scrutiny even during the pandemic. So today, we're going to look back and discuss PBM's audit trends, which includes invoice reconciliation, bona-fide prescriber-patient relationship, member verification, copayment collection, prescriber and patient denials. We will also discuss what we should expect in the new year, as well as legal tools that are available to pharmacies to challenge the audit findings. So let's start with the invoice reconciliation. PBMs routinely conduct invoice reconciliation audits by comparing purchase reports to dispensing reports. I mean, especially this year, PBMs have been using this audit regularly because it does not take too much of a resource to conduct an invoice reconciliation audit. Any indication that the pharmacy dispensed a higher quantity of a medication than what was purchased will result in drug invoice shortages. So in essence, this is a basic math comparing what the pharmacy bought versus what the pharmacy dispensed. However, PBMs make it more complicated than it should be by labeling other issues under the category of drug invoice shortages and by not being transparent about the underlying reasons for allegations. So let's look at a couple case studies. Case study number 1. PBM purposely limit their review of the purchase records to a specified audit period, resulting in inventory shortage. So let's say the audit period is from January 2019 to January 2020. PBMs do not account for purchases made in December 2018 unless the pharmacy requests wholesalers to provide purchase records from that month and demand PBM to include such records during the invoice reconciliation audit. The fact is that pharmacies make purchasing in advance and not the date of submitting claims. So if PBM continues to allege drug invoice shortage discrepancies, the pharmacy should take the next step and demonstrate that the pharmacist did in fact have sufficient inventory of drugs compared to what is submitted to the PBM. That said, when responding to invoice reconciliation audits, pharmacists should request their wholesalers to provide purchase records starting from the 3 months prior to the beginning date of the audit period, and be prepared to provide details as to the purchase amount versus the dispensed amount. Second case study is that pharmacies must request their wholesalers to provide purchase records directly to PBMs, because PBMs will not account for purchase records provided by the pharmacy. On that note, it is recommended, in fact highly recommended, that pharmacies request wholesalers to copy the pharmacies when the wholesalers send the purchase records to PBMs. I mean, it is important that pharmacies have copies of the purchase records for several reasons. Number 1, having a copy of the purchase records submitted by the wholesaler gives the pharmacy an ability to track what was submitted to PBMs in the event that PBMs claim that the pharmacy failed to respond to the audit request, and this happens quite often. It also allows the pharmacy to have more efficient meet and confer or dispute call with the PBMs. Additionally, by being copied in the wholesaler's submission to the PBMs, it actually creates a backup file, or let me put it this way, it forces the pharmacy to have a backup file in the event that the wholesaler closes their businesses. I mean, this is especially important when the pharmacies are purchasing drugs from smaller wholesalers that provide a better price. Third, PBMs regularly allege that the pharmacy purchased drugs from a non-licensed supplier. What is disturbing about this scenario is that the audit comments provided in the audit findings will not explicitly say that PBMs did not account for the purchase records because the pharmacist did not provide a copy of the wholesaler's license. Instead, it will merely say that the documents provided the pharmacy or the wholesaler do not meet the audit guideline. So the pharmacy has to jump through hoops to obtain additional information from the PBMs, and it is not easy for an independent pharmacy while spending their resources and time with treating patients to contact the PBMs. And when you contact the PBMs, it is not easy to get in touch with the person who actually knows or who has access with the audit findings. So in any event, the pharmacy has to jump through hoops to actually get the underlying basis of the drug invoice shortages in this scenario. The other option is that the pharmacy has to exhaust the dispute resolution procedure warranted under the PBM's provider agreement and provider manual in order to have a meet and confer or a dispute call to hash out the details. It's only then the PBM will disclose the true underlying basis of drug invoice shortage discrepancy. Now, more troubling is that PBMs may have already withheld the entire reimbursement amount of the claims at issue, even before the meet and confer. So PBM's egregious audit practice has already at that point affected the pharmacy's day-to-day operation, as well as the pharmacy's patient care. The fourth case study involves pharmacies buying drugs from other pharmacies, regardless whether they are commonly owned, associated, or related. In that instance, PBMs will likely allege that the purchase records, including the wholesaler's invoices and proof of payment, are not accepted because those products were in fact purchased from another pharmacy. Importantly, purchasing a non-controlled drug from another pharmacy is not generally prohibited by law. So the pharmacy should be prepared to dispute such discrepancy with supporting documentation, which include inventory of the purchased drugs, proof of payment, and wholesaler invoices, and consult with a pharmacy attorney or other industry experts to discuss applicable federal and state law that the pharmacy can use to refute the PBM's refusal to accept the valid purchases. The last case study involves shipping address discrepancy. More specifically, I've seen instances where PBMs do not account for purchase records because the address of the pharmacy on the invoice is different from the pharmacy's address in the PBM's file. I mean, it sounds very bizarre, but such allegations were in fact made by the PBMs. PBMs are Fortune 500 companies with very, very deep pockets. The vertical integration of the PBMs with the payers and their own pharmacies makes them even bigger, both financially and physically. However, they're not always right. And in fact, they're incorrect on many instances. So this discrepancy is the prime example where PBMs fail to update their file with the current mailing address of the pharmacy. I've encountered this allegation on a number of occasions, but only during or after the notice of dispute phase of the dispute resolution procedure. It means that only after we invoke the pharmacy's rights under the dispute resolution procedure, PBMs will disclose the true underlying basis of this allegation. So the pharmacies are forced to exhaust its time and resource before procuring the underlying basis of this type of drug invoice shortage discrepancy. Again, to make matters worse, PBMs may take their time to issue a revised audit findings or release the reimbursement withholdings only after the pharmacy provided evidence showing that it submitted a notice of change of address to PBMs in a timely manner. So there was a pharmacy who actually had this issue, and the pharmacy was able to provide evidence or a document showing that they did in fact submitted a notice of change of address back in 2016. And even then, it took several months for the PBM to release the money that they withheld. So whenever pharmacies face or encounter this type of invoice reconciliation discrepancies, the pharmacy should demand that PBM immediately release any and all monies withheld on clean claims. Like states, including Pennsylvania, has prompt pay laws that the pharmacy can rely upon. We will discuss the prompt pay law and other legal tools available to the pharmacies towards the end of this webinar. So now let's talk about the purchase records and relevant documents that the pharmacy should maintain in anticipation of invoice reconciliation audit. First, pharmacies must be aware of the track and trace requirements in compliance with the Drug Supply Chain and Security Act. PBMs regularly request track and trace documents during an invoice reconciliation audit. The track and trace documents are broken down into three parts: transaction history, transaction information, and transaction statement. These documents are called T3 documents. Now, transaction information includes the following information: the proprietary or established name or names of the product, strength and dosage form of the product, NDC number, container size, the number of containers, lot number of the product, date of transaction, date of shipment, a business name and address of the person from whom the ownership of the product is being transferred, and business name and address of the person to whom ownership of the product is being transferred. So it includes, it lists 10 requirements to be included in the transaction information. These should be included in the pedigrees provided by the wholesalers. But it's the pharmacist's responsibility to make sure that these information are part of the invoices and pedigrees provided by the wholesalers, and pharmacists have to maintain them. Now, transaction history is a statement that details all information on all transactions for a product, starting with the manufacturer. Transaction statement is a statement that states that the trading partner, aka wholesalers or other trading partners recognized under the Drug Supply Chain and Security Act, including pharmacies, is authorized to transfer the ownership, receive the product from an authorized entity, receive the transaction information, and the transaction statement from the prior owner of the product, and that the trading partner did not knowingly ship a suspect or counterfeit product, and that the trading partner has systems and processes in place to comply with the verification requirement, and that the trading partner did not knowingly provide false transaction information, and that the trading partner did not knowingly alter the transaction history. This is a laundry list of a pedigree and the track and trace document requirements. I know it's a lot, but pharmacies must maintain these documents, and PBMs, they do request pedigrees and track and trace documents. And if any of the laundry list of the requirements are missing, PBMs will impose penalties and discrepancies upon the pharmacy. Another invoice reconciliation requirement imposed by PBMs is the requirement to purchase diabetic testing supplies from manufacturers, authorized wholesalers. Major PBMs do in fact require pharmacies to purchase diabetic supplies only from the distributors authorized by the manufacturer. This requirement stems from the concern of so-called black market of the test strips. So pharmacies should never buy back test strips from unauthorized wholesalers or individuals. Another issue that frequently comes out during invoice audit of testing supplies is NDC discrepancies. Certain diabetic supplies from the same manufacturers do in fact have different NDC numbers. Sometimes it is only a matter of bulk packaging versus individual packaging unit. It is always recommended that the NDC of the submitted claim should match the NDC of the dispensed product. However, there could be an argument to be made if the NDC are for the same product and the only difference is the packaging size. In the similar vein, several PBMs require pharmacies to only purchase drugs from VAUD-accredited wholesalers. If the pharmacy do not abide by those requirements, PBMs will impose, drug invoice shortage discrepancies and recoup the entire reimbursement on a paid claim. So, which PBMs are scrutinizing the drug supply chain? Today, Caremark, ESI, Prime, and Optum require the pharmacies to maintain and provide track and trace documents. These documents should be maintained by the pharmacy for not less than 6 years after the transaction. So I cannot stress enough that PBMs will request these documents and the pharmacy should be prepared to submit them. Otherwise, the pharmacy will not only face reimbursement recoupment, which could be a significant amount, but also network termination. Now, with respect to BAUD requirements, Optum is notoriously known for penalizing pharmacies for not purchasing drugs and non-legend items from non-BAUD accredited wholesalers. So when processing Optum claims, please keep in mind the BAUD requirements set forth by Optum. In addition to the invoice reconciliation audit practice, bona-fide prescriber-patient relationship discrepancies have come up fairly often during the prescription audits. PBMs apply different discrepancy types to bona fide prescriber-patient relationship discrepancies. So what is bona fide prescriber-patient relationship, and under what context does it come up? So bona fide prescriber-patient relationship exists when the prescriber actually consults with the patient and reviews the patient's medical history. And the prescriber created and maintained records of patient's condition in accordance with the medically accepted standards. So when PBMs ask for supporting documentation, they believe that the claims at issue have been generated through marketing initiatives, whether such marketing efforts were initiated by the pharmacy or another marketing professional or so-called sales rep. So the types of documents that PBMs would accept to reverse the bona fide prescriber-patient relationship discrepancies include medical records, prescriber attestation, and patient attestation. When requesting these documents, PBMs know it will be fairly difficult for pharmacies to obtain the documents. In fact, many states, if not all, do not require the pharmacies to maintain such records as part of the record retention policy of the pharmacy. Furthermore, the claims examined by the PBMs during an audit involved prescriptions that were filled and dispensed by the pharmacy at least a year or 2 years ago. Which makes it even more challenging for the pharmacies to obtain records from the prescriber. To make matters worse, we have seen instances where PBMs insisted that prescribers' attestations must be written on the prescriber prescription pads. So, what constitutes a bona fide prescriber-patient relationship often varies from state to state and is dependent on the facts. Therefore, the pharmacist should be cognizant of the current laws and regulation, and they should implement a robust record retention practice. On that note, it is worth noting that certain PBMs manuals require the pharmacies to provide evidence of verification of legit prescriber-patient relationship only when the pharmacy knows or reasonably should have known that there is not a valid prescriber-patient relationship. If the pharmacy is unable to provide these the requested documents, then my recommendation is that the pharmacist should endeavor to provide other records, including contemporaneous pharmacy notes that memorialize the pharmacist's communication with the prescriber and/or the patient. Pharmacy notes, including patient profile, showing that the prescriber had prescribed medication to the patient on a regular basis, should be sufficient. The upward trend in demanding the pharmacies to prove bona fide prescriber-patient relationship is an unnecessary audit practice that only benefits PBMs, especially when the prescriptions are facially valid and compliant with the applicable federal and state laws. So in the event that the pharmacy fails to provide the requested document, PBMs will claw back the entire reimbursement amount. It's such an egregious audit practice and the subsequent clawback places another layer of financial burden upon the pharmacies. I mean, many of the pharmacies are already in financial trouble due to various self-serving schemes implemented by PBMs. Onerous member verification is another audit practice that has been on the rise throughout this year. For these, PBMs allege that the pharmacies dispensed prescription to their patient, but the delivery address does not match with the address on their file. PBMs will continue to allege these discrepancies even when the pharmacy provided signature logs and or proof of delivery. The documents that PBM will accept to reverse these discrepancies include the pharmacy's out-of-state license if such prescription was delivered outside of the state where the pharmacy is located, and patient attestation. In many of the cases that I've seen, the patients are either simply visiting from out of state on a vacation, temporarily staying with a family member, or even college students who have a second home in a different state at the college or university they're attending. So to audit and subject the independent pharmacies merely because of the unmatched address is unreasonable and abusive audit practice. With that backdrop, pharmacies should endeavor to provide additional context to the prescription history along with the contemporaneous pharmacy notes to refute the alleged discrepancies. Well, as you may know, copayment collection continues to be one of the top audit practices. I mean, I'm sure you've heard this before, but it is extremely important that pharmacies maintain copayment policies and procedures that are in line with the current federal and state law. Also, pharmacies must document its efforts to collect copays from patients. PBMs will ask for documents, including but not limited to deposit slips, payment receipts with last 4 digits of the credit card, even copies of the checks, and patient attestation. And if a pharmacy decides to enroll a patient into its financial hardship program, then the pharmacist must be able to show a document that would justify allowing the patient to participate in the program. It is not enough for a pharmacy to just make a statement that the individual or the patient is having a financial hardship. You need to have a backup document. You need to have a backup data to justify placing the patient into the program. And of course, you need to have a valid program and standard operating procedure written for that specific program. Also, with respect to coupons or patient savings card, the pharmacy must adhere to the terms of the use noted in each coupon program. More importantly, these coupons should not be used on government claims, that is like Medicare, Medicaid, or TRICARE claims. Additionally, I want to highlight that there has been a series of lawsuits filed by manufacturers against pharmacies involving the manufacturer coupons. In these lawsuits, manufacturers are alleging that the pharmacies improperly used a coupon program and demanded significant amount of money from the pharmacy, ranging from tens of thousands of dollars to millions of dollars. Prescriber and patient denials continue to be the go-to audit discrepancy. Prescriber denial discrepancy occurs when the prescriber denies writing or authorizing prescription to a patient. Patient denial discrepancy occurs when the patient denies receiving the prescription from the pharmacy, the patient denies seeing the prescriber, or when the patient denies requesting the medication to be filled at the pharmacy. PBMs, do in fact contact the prescriber and the patient to verify the claims. However, PBMs apply prescriber and patient denial discrepancies even when the prescriber and patient are unavailable or unresponsive. Not only that, the pharmacies have reported that patients described their calls with the PBMs as intimidating and felt like they're under an investigation. So it is not surprising that such calls may prompt patients to respond in a way for PBMs to claim patient denials. In order to reverse these discrepancies, pharmacies are tasked to provide attestation from the patient and the providers. Thus, it is important that pharmacies maintain regular contact with the patient and the prescribers. That's it for the recap of audit trends in 2020. In the upcoming year, I envision that the PBMs will pick up their audits, focusing on the audit practices that we discussed thus far. Also, it is reasonable to assume that the PBMs will focus on claims that have been submitted during the peak of the pandemic, and the pharmacies should be prepared to provide supporting documents, or remind PBMs that such documentation was waived by the PBMs. Like, for example, Caremark waived the signature log requirement. Optum waived the signature log requirement. Optum also indicated that they suspended on-site and desktop audits. Well, Optum recently began the on-site audit via virtual audits. ESI indicated that they will be accepting alternative documentation for signature log, and also indicated that they suspended on-site and desktop audits. To be clear, ESI, they don't really do audits. What they do is fraud, waste, and abuse investigation. So their gesture, their good faith gesture that they suspended on-site and desktop audits is sort of meaningless. Humana indicated they will accept point of sale documents showing the date and time that the prescription was sent out in lieu of the patient's signature. They also waived mail and delivery restriction, but only for the month of March and April 2020. So there are legal tools available to challenge the PBM audit findings, such as besides providing supporting documents. For example, fair pharmacy audit laws, prompt pay laws, unfair practice laws. So for fair pharmacy audit laws, it actually governs the PBM's audit practices. So for example, PBMs may not charge back on a claim for a clerical or record-keeping error. For prompt pay law, under the prompt pay laws, it actually requires PBMs to remit payment on a clean claim without a statutory period. I believe for Pennsylvania, you have the PBMs as 45 days from the date the claim was submitted to pay for that clean claim. Now, under the protection warranted under the unfair trade practices laws, it actually prohibits PBMs from engaging in unfair or deceptive business practices. Sometimes, or more so, it provides a private right of action along with the attorney's fees and punitive damages. So, pharmacies should consult with the pharmacy attorneys to evaluate the options that are available to them. It is critical that the pharmacies dispute audit discrepancies to the best of their ability, because PBMs will not only recoup the entire reimbursement paid on claims that were already dispensed to the patient by the pharmacy, but also use the discrepancies to form a basis of network termination. Paying the discrepant amount doesn't mean that discrepancies are resolved. It's still there. Pharmacists must dispute and reverse the discrepancies, and only then the discrepancies are resolved. I don't have anything further, so thank you for your time today. I'll take some questions for a few minutes if you have any.
All right, Dave. Well, thank you for the presentation today. This concludes today's webinar. a look back at PBM trends and what pharmacies should do now to prepare for the new year. The recording will be sent out by the end of the week. Thank you for joining and have a great rest of your day.